the mistrial in the case yesterday. Are you surprised?
No, I mean, the narratives of this trial were so polarized and extreme that it is unlikely that a jury could have agreed. Unless they all agreed that they each had their own different doubts, I would have expected that they couldn't come to an agreement. And the note from the juror suggests, from the foreperson, suggests that the division was broad, that it wasn't just one outlying juror who couldn't be brought around to one view or another, but that instead there was a real deep division, and each side, if you will, was firmly convinced of their truth.
What does it look like going forward? So the state has up into a year to retry the case. Is that correct?
Yeah, and they immediately responded to this mistrial by loudly declaring that they would try it again, which is what you do in that moment. Will that be their position a month from now? I think they're going to do some very deep thinking and stock taking to figure out what's going to be different the next time. How is it going to be easier or better or more persuasive? Because this has to be viewed as a failure from their perspective in terms of their ability to convince a jury of the truth of their narrative. They just weren't able to do it.
Do you think ADA Lally will take the case again, or will someone else be the prosecutor this time?
Well, I mean, obviously exhausting to have gone through this process as the lead attorney. So certainly some time in between to regroup. But no one knows the case better. It doesn't make sense for someone else to take the lead. No one knows the details, the nitty-gritty better than those who tried the case. So it's unlikely that they would hand it off to someone else. On the other hand, they may do some reevaluating of what they can use second time around and what's going to have to be put aside because it did not work for them.
Is it possible that the case would be moved to a different city? Obviously, this has been highly publicized. Do you think that they would be able to find a jury that doesn't know about the case a second time around?
One of the great things about this country is that you can always find people who have no idea what everyone else is talking about. And we have had many more dramatically, publicly covered crimes than this, where we've been able to impanel a jury. I mean, the examples that spring to mind, of course, the Boston Marathon bombing trial and other very high-profile trials. The fact that they could get a jury for Donald Trump in New York. And yes, everybody knows who he is and everybody knows roughly what he's accused of. But the question for the judge when allowing jurors to sit is this a person who can set all that aside and decide the case just based on the evidence? And generally speaking, the answer is yes. It's really very rare to move a trial to some other location. By the way, the coverage here has been not just county-wide, but statewide and now really national. So what would the remedy be, really? It's not going to be that another county is going to be less affected by this gavel-to-gavel coverage.
Mm-hmm. Now, obviously, the announcement that Trooper Michael Proctor was relieved of his duty, can he testify in the next trial now?
Of course he can testify, but he's going to be a pretty problematic witness. Already the fact of his conduct, the texts that he was sending, that came in the first time around and really caused the Commonwealth a real harm. But now, if he testifies, they're also going to have to tell the jury that he's been relieved of his duties. So that undercuts his authority as the investigating officer, I think, profoundly. So he's going to be an even less valuable witness than he was the first time around. The question is, how does the Commonwealth make their case without him? Can they? I mean, he led the investigation. He called the shots.
Mm-hmm. So if this were, to go to another trial, they retried the case, do you think they would call him or leave him out? Or how bad would that look to a jury?
I just think they lose either way. They lose either way. If they call him, all of this comes out. The texts again, and the fact of his being removed in this way, which is very unusual. That's all going to come out. Can they make the case with other bits and pieces? Can they have someone else give the narrative when his name keeps coming up? And the jury has a question mark. Why haven't we heard from him? So I think that is an enormous pressure on the Commonwealth to figure out how else can we get to our goal in this case without without having to run these risks and bear these costs.
Mhm. In your experience, a retrial, does that usually result in a conviction or does it all depend on the case?
I think it all depends on the case. You know, the most recent history that a number of folks have reported with Judge Quinones is that there was a homicide trial that she tried to a mistrial, and then the retrial resulted in a conviction. That was a case, I think, involving a mental illness defense. So it's just very fact specific in particular. What I think is interesting here is that the two sides gave these polarized narratives. Either she did this intentionally, or she's the victim of a frame up. What about if we offer an intermediate narrative that says maybe she didn't do it intentionally, but maybe she thought she left him safe and sound, but actually she drove so dangerously that she struck him without knowing? Maybe the jury can be offered some intermediate narrative that can be a place where they meet.
Mhm. And do you think if the case is retried, they'll drop the second-degree murder charge?
I think they have to do some hard thinking about whether they can even aim for a second-degree murder charge. The fact that it's in there in the indictment doesn't mean they can't offer an alternative narrative of a kind of manslaughter or recklessness. They can tell multiple stories. I mean, the common wisdom is you pick one story, one theory of your case, and you stick with it. But I think there's some temptation here now to say either she did this intentionally or maybe she did it recklessly and she was not careful. She had too much to drink. She was angry and upset. But when she came back at 6, she was genuinely surprised that what she did was hit him. That's a different narrative from the one they offered in the first trial.
Hmm. So do you think they'd have to take away that second-degree murder charge to maybe get a conviction?
They don't take it away. In other words, it can be in there. And then the jury has a kind of a menu of choices of what they think the state has proven.
Mhm. Is there anything else that you want to add or you think is important about this trial? I know it was a long trial, a lot of
Yeah.
evidence.
What I think is interesting and has not happened yet is the jurors have not spoken publicly. Now, no one is allowed to reach out and ask for their point of view. That's prohibited here in Massachusetts. Lawyers are not allowed to reach out to the jury, but the jury's free to speak. So in the coming days, I think there may be some jurors who are tempted to say, I want to tell my story. I want to let you know what we were thinking in that room. I don't want people to think we were careless or not reflective. We were, and here's what happened. And if one juror speaks, then maybe another will, and then we'll have a really rich pool of information to figure out what evidence was persuasive and what evidence was a problem.